Be ready. Start. Section 7 of the Impugned Act empowers the central government, notwithstanding any prior judgments or existing laws, to frame rules prescribing the salary of the chairperson and members of a tribunal. They are entitled to receive allowances and benefits equivalent to those admissible to a central government officer holding an equivalent pay level. The provision also allows a higher reimbursement of house rent beyond the standard house rent allowance if the chairperson or member resides in rented accommodation subject to limits and conditions specified by rules. Further, once appointed, neither the salary and allowances nor any other terms and conditions of service of the chairperson or member may be altered to their disadvantage. The Impugned Act also amends multiple statutes, including the Industrial Disputes Act, Cinematograph Act, Copyright Act, Income Tax Act, Customs Act, Patents Act, Administrative Tribunals Act, Railway Claims Tribunal Act, SABI Act, Recovery of Debts and Bankruptcy Act, Airports Authority of India Act, TRI Act, Trademarks Act, National Green Tribunal Act, Companies Act and Consumer Protection Act. In these acts, references to earlier tribunal provisions under the Finance Act 2017 are replaced with references to the Impugned Act. Several specialized tribunals or appellate boards are abolished and their functions are shifted either to high courts, commercial courts, or designated authorities. Many sections establishing or regulating appellate boards, tribunals, or appellate mechanisms are omitted and related procedural provisions are updated. Section 183 and 184 of the Finance Act 2017 along with the 8th schedule are deleted. For bodies like the National Consumer Disputes Redressal Commission, the qualifications, appointments, tenure, salaries, and removal of members appointed after the Impugned Act are now governed entirely by the Impugned Act. Section 33 of the Impugned Act provides that despite anything contained in existing laws, all persons serving as chairpersons, presidents, presiding officers, vice chairpersons, vice presidents, or members of the tribunals, appellate tribunals, and other authorities listed in the second schedule shall cease to hold office from the notified date. They are entitled to compensation of up to 3 months' pay and allowances for the premature termination of their tenure or contractual service. Officers and employees serving on deputation in these bodies will automatically revert to their parent cadre, ministry, or department on the notified date. All pending appeals, applications, and proceedings, except those before the authority for advance rulings under the Income Tax Act will stand transferred to the court in which they would originally have been filed had the impugned act been in force at the time, and the court may continue the matter from the existing stage or any earlier stage, or even conduct at a de novo hearing. The wires of these provisions have been challenged on various grounds. We have extensively heard Sri Arvind P. Dattar and Sri C. S. Vaidyanathan, learned senior counsel appearing for the petitioners and others. Now, it is not so. We have also extensively heard Sri Venkataramani, learned Attorney General of India, and Miss Aishwarya Bhati, learned Additional Solicitor General, appearing for the Respondent Union of India. The gist of the arguments advanced by the learned senior counsel appearing for the petitioners. Several provisions of the Impugned Act, particularly sections 3, 1, 3, 7, 5, and 7, 1, violate the constitutional principles of separation of powers and judicial independence by diluting the judiciary's role in appointments, tenure, and service conditions of tribunal members. These provisions infringe the basic structure and contravene Articles 14, 21, and 50 of the Constitution, as well as binding decisions of the court. The Impugned Act amounts to an impermissible legislative overruling of judicial directions, particularly by enabling the executive, through delegated rule-making powers, to undo safeguards prescribed by the court. The delegation of authority to the executive to frame rules regarding appointments, allowances, and conditions of service is excessive and encroaches upon core judicial functions. The Impugned Act also nullifies judicially framed rules by reintroducing provisions previously struck down, such as the minimum age requirement, a truncated 4-year tenure, and the process of recommending multiple names, thereby frustrating the court's directions. These provisions violate the legitimate expectations and vested rights of sitting members regarding tenure, reappointment, allowances, and house rent allowances. The Impugned Act imposes arbitrary age and tenure restrictions that discourage meritorious candidates below 50 years from joining tribunals. Section 3, 7 of the said Act limits judicial oversight by requiring the SCSC to forward 2 names per vacancy and directing the government to act preferably within 3 months. The executive's control over allowances and house rent entitlement compromises judicial independence, while the continued failure to establish an independent National Tribunals Commission leaves tribunals under executive control, particularly within the Ministry of Finance. The gist of the arguments advanced by the learned Attorney General for India appearing for the respondents on behalf of the Union of India, the primary contention is that courts cannot compel the legislature to enact a particular law or structure a statutory framework in a specific manner. Law making is a domain reserved for the legislature, and judicial review cannot be used to prescribe the contents of legislation or to mandate how qualifications, age limits, or tenures should be framed. The Union further argues that the power of the courts to issue mandamus arises only when there is a clear public duty imposed by law. If the statute does not create an obligation to frame rules or make appointments in a particular form or within a fixed timeline, courts cannot direct the executive to do so. Similarly, non-compliance with judicial directions that intrude into the policy-making space of the legislature cannot attract contempt because the authority to frame rules is vested in the executive and parliament. The parliament is fully competent to redefine qualifications, eligibility, or selection processes for tribunals. These matters fall squarely within legislative policy, and courts are not expected to sit in judgment over the wisdom of these choices. Even if judicial guidelines were earlier issued regarding tribunal appointments or service conditions, Parliament can modify the underlying legal framework through a valid law, and doing so would not amount to overriding judicial authority but merely exercising its constitutional role. The independence of the judiciary is also stated to be unaffected where the tenure or service conditions of tribunal members are prescribed by statute, since tribunals are creatures of legislation. It has been added that prescribing age limits or tenures does not by itself compromise judicial independence. A statute can only be invalidated for lack of legislative competence or violation of constitutional provisions. It cannot be struck down for not conforming to directions previously issued by the judiciary or because courts consider an alternative structure preferable. Ultimately, the Union seeks to assert that the impugned act represents a legislative policy choice. Parliament's decisions on qualifications, age criteria, tenure, and administrative arrangements for tribunals therefore deserve deference unless they breach explicit constitutional mandates. To give full picture of the present case, it is necessary to trace the historical trajectory to understand how the developments leading up to the Impugned Act have shaped the current dispute before the court. To ensure specialized, efficient adjudication and speedy resolution of specific categories of cases, India introduced the system of tribunals. Part 14A was incorporated into the Constitution through the 42nd Amendment Act 1976 under Article 323A. Parliament is empowered to establish administrative tribunals for service related matters, while Article 323B enables the appropriate legislature to constitute tribunals for other enumerated subjects. In pursuance of Article 323A, Parliament enacted the Administrative Tribunals Act 1985, providing for the establishment of administrative tribunals to adjudicate service disputes of public servants. The constitutional validity of this enactment came under challenge before a constitution bench in SP Sampath Kumar versus Union of India and others, where the court was called upon to consider two principal issues. First, whether the exclusion of the jurisdiction of the high courts under Article 226 and 227 in service matters was constitutionally permissible, and second, whether the composition of the tribunals and the method of appointment of the chairman, vice chairman, and members conformed to the requirements of the Constitution. Writing for the court, Justice Ranganath Mishra, as his lordship then was, held that the tribunal should be a real substitute of the High Court, not only in form and de jure, but in content and de facto. It opined that the chairman of the tribunal office should, for all practical purposes, be equated with the office of Chief Justice of a High Court, and that a retiring or retired Chief Justice of a High Court, or when such a person is not available, a senior judge of proved ability, either in office or retired, should be appointed. The reason was that judicial discipline generated by experience and training in an adequate dose in a judicial office is a necessary qualification for the post of chairman. Regarding the selection of vice chairman and members, the court held that such selection, when it is not of a sitting judge or retired judge of a high court, should be done by a high powered committee with a sitting judge of the Supreme Court to be nominated by the Chief Justice of India as its chairman. This will ensure selection of proper and competent people to man these high offices of trust and help to build up reputation and acceptability. It was further observed that prescribing a tenure of only 5 years for the chairman, vice chairman, and members of the tribunal could act as a deterrent to attracting competent candidates, particularly from younger age groups who would retire long before the usual age of superannuation, since appointees were required to resign from their previous posts. A short tenure offered little security or continuity. The court noted that such a limited term was neither convenient for the appointees nor conducive to the effective functioning of the tribunal system, as members would often leave just as they had gained, adequate expertise in service jurisprudence. The Union government was directed to make changes in the Act in line with the judgment. In his concurring opinion, Chief Justice P.N. Bhagwati observed that the position of chairperson should not be held by an individual who has merely served as a secretary to the government of India, since such a role does not necessarily involve the development of a judicial temperament. As regards the appointment of vice chairpersons and members, he emphasized that district judges and advocates qualified to be appointed as judges of the High Court should also be considered eligible for election. In a review petition filed in the case, the court clarified that appointments to the Central Administrative Tribunal should be made through a high powered selection committee headed by a sitting judge of the Supreme Court nominated by the Chief Justice of India. For state administrative tribunals, a similar committee should be chaired by a sitting judge of the concerned High Court nominated by its Chief Justice, rejecting the Attorney General's contention that advocates lacked administrative experience to serve as vice chairpersons. The court held that an advocate qualified to be a High Court judge is inherently competent to discharge both judicial and administrative functions. Insofar as the exclusion of the power of judicial review exercised by the High Court in service matters under Article 226 and 227 of the Constitution by virtue of Section 28 of the Administrative Tribunals Act 1985 is concerned, the Constitution bench held that the exclusion of judicial review was not whole inasmuch as the jurisdiction of this court under Article 32 and 136 of the Constitution had been kept intact. Though it was held that the power of judicial review is a basic and essential feature of the Constitution, but if any constitutional amendment made by the Parliament takes away from the High Court the power of judicial review in any particular area and vests it in any other institutional mechanism, it would not be violative of the basic structure doctrine. In R.K. Jain versus Union of India, a three-judge bench dealt with a complaint concerning the functioning of the Customs, Excise, and Gold Control Appellate Tribunal, which was set up by exercising the power conferred by Article 323b. In his leading opinion, Justice K. Ramaswamy observed that tribunals established under Articles 323a and 323b of the Constitution or under any statute are creations of the legislature and cannot claim the same status, parity, or substitution as high courts or their judges. Nevertheless, it was reiterated that the individuals appointed to such tribunals exercise judicial or quasi judicial functions and must therefore possess a judicial approach along with adequate knowledge and expertise in relevant branches of constitutional, administrative, and tax law. Subsequently, the judgment in S.P. Sampath Kumar Supra was recognized by a seven-judge bench in L. Chandra Kumar versus Union of India and others. The court held that the High Court's power of judicial superintendence over all courts and tribunals within their jurisdiction forms part of the basic structure of the Constitution. While tribunals cannot exercise judicial review of legislative action to the exclusion of the High Courts or the Supreme Court, they may perform a supplementary, though not a substitutive, role in this regard. The court declared Article 323A 2D and Article 323B 3D unconstitutional insofar as they exclude the jurisdiction of the High Courts under Articles 226, 227, and the Supreme Court under Article 32, holding that all tribunal decisions remained subject to the writ jurisdiction of the division bench of the concerned High Court. The court also examined the qualifications and competence of the individuals appointed to the tribunals as well as the question of which authority should exercise administrative supervision over them. It has been brought to our notice that one reason why these tribunals have been functioning inefficiently is because there is no authority charged with supervising and fulfilling their administrative requirements. The creation of a single umbrella organization will, in our view, remove many of the ills of the present system. If the need arises, there can be separate umbrella organizations at the central and the state levels. Such a supervisory authority must try to ensure that the independence of the members of all such tribunals is maintained. To that extent, the procedure for the selection of the members of the tribunals, the manner in which funds are allocated for the functioning of the tribunals, and all other consequential details will have to be clearly spelled out. In other words, the court stated that an independent nodal body would help secure institutional autonomy and safeguard the independence of tribunals. Independence of tribunals was then emphasized by a constitution bench. The president of the Madras Bar Association challenged before the High Court the constitutional validity of an amendment to the Companies Act 1956 that established the National Company Law Tribunal and the National Company Law Appellate Tribunal. It was argued that the constitution of the NCLT and the transfer of the entire company jurisdiction of the High Court to the tribunal, which is not under the control of the judiciary, are violative of the doctrine of separation of powers and the independence of the judiciary, which are part of the basic structure of the Constitution. The High Court found several provisions to be defective and violative of the constitutional principles of separation of powers and judicial independence. कैसे लिखो पेज भरेगा हाँ?